and I welcome you all on behalf of Krishna Academy. Our today's topic for discussion would be acquisition of land, law relating to acquisition of land in India, special reference to National Highways Act 1956, as well as Right to Information Act 2005. I will not directly go upon to this topic because I am hoping that few more students will join, as the link of this lecture was shared in the last moment in our WhatsApp group. Therefore, before starting our topic, it is important for me to mention before you that this discussion on topic of land acquisition, law relating to land acquisition, is important from the aspect of your RTI topic, right to information, where you all have been asked to file RTI applications, and the one who will be filing more applications continuously pursuing it with first appellate authority and second appellate authority, that is State Information Commission, in case of state offices, state government offices, and in case of central government offices, Central Information Commission. So by way of today's lecture, I will be suggesting you 2 to 3 more topics, or we can say directions, where you all can file this RTA application. That filing of RTA application and the documents which you all guys will be seeking will be relating to land acquisition. So during the process of land acquisition, there is one authority which is termed as land acquisition officer, or the competent authority land acquisition. So apart from many other RTA applications which will be suggested to you in other classes, such as with your Gram Panchayat, with your other concerning local bodies like municipalities, Nagarpalikas, or other government department like Tehsildar department, subdivisional department, district collectorate department. These all are those government offices where you can file the RTA application and seek the documents relating to expenditure in public work and other documents which are public document and entrusted with that particular department. But apart from that, there is also a land acquisition department where you can file RTI. So the first importance of today's lecture will be, it will give you more topics where you can file RTI application. Second important thing about this lecture will be that after knowing a little bit about the process of land acquisition in our country, the law relating to land acquisition, you guys can also practice in this particular field. Nowadays, the land acquisition around our country is growing. You all guys must be knowing the acquisition of land by National Highway Authority or the Ministry of Road Transport for the purpose of construction of highways, acquisition of land by the Ministry of Railways for the purpose of four-laning of new rail projects. There are acquisitions by the government for particular special companies, particular special projects. There is acquisition by state government for construction of state highways. And apart from that also, there are many more acquisition proceedings which are currently going on in our country. You guys will be surprised to know that in last 5 to 6 years, since I am from Rajasthan, there might be students who are from any other state. But in Rajasthan itself, the Ministry of Road Transport and Highways has acquired more than 50,000 hectare of land for the purpose of construction of national highway. Meaning thereby, around 2 lakh bighas of land has been acquired for the construction of national highway. When a land is acquired for construction of highway, a compensation is paid to the landowner whose land has been acquired. And that compensation, how that compensation will be determined, what is the procedure of that land acquisition, how the gazette notifications are made by the government, what type of dispute that arose during that land acquisition proceeding. There can be dispute relating to entrustment, entitlement, disbursement. All those disputes are being taken care by the advocates by representing their different clients. Because of the huge amount of land acquisition in past 5 to 10 years, the litigation of land acquisition has also in rise. Therefore, it has become important that our young advocates who are entering in this field of practicing law must know the law and also the points and the different provisions under which they can protect their client's right. So, land acquisition. Land acquisition is the power of central government, or that may be said state government in that case, because this particular field has been given in the concurrent list of our constitution. Therefore, both central government as well as state government can make laws on land acquisition. When we start studying land acquisition, the first word which must be studied is the power of eminent domain. The power of eminent domain is with the concerning government, which is sovereign. And this means the complete owner or the supreme owner. As you all guys must be aware that the land which we own, our family members own, is not the absolute ownership of that land. Under law, it is presumed that the land belongs to particular government. Since we are a sovereign independent country, the, that land vests in central government, or in that case state government. Before this sovereignty, when we were under the British colony also, then the land was owned by concerning Raja or that Governor General of that British Empire. Therefore, our law, which was before the year 2013 for acquisition of land, was Land Acquisition Act 1894. This law was made by the British Empire when they were ruling in India. But the law was such a law that this law continued till the year 2013 in our country. Although it went to several amendments after our independence, the major amendment was in the year 1984, but still we continued with the same law for land acquisition. Now, before coming to the particular provisions or interesting provisions of law of land acquisition in 1894, we must also note that there was a provision under our constitutional chapter Fundamental Right, which was subsequently repealed by 44th Constitutional Amendment. That section was Section 31, which provided for compulsory acquisition of land. And in that particular provision, since it was under the heading of fundamental right, this provision was subsequently repealed because of certain litigation. You guys must be aware that at the initial phase of our independence, the major focus of our government was to bring equality by distributing the land from the persons who were having major holdings of lands to the persons who were not having any land. And in that process, several laws were enacted by concerning state government. Challenges were made to those laws on the basis of their constitutional validity. And after the various judgments of Supreme Court, High Court, finally the law, that is 44th Constitutional Amendment, repealed Section 31 from the Constitution of India. After said repealment, a new provision was inserted in our Constitution, that is Article 300A, which provided that no person shall be deprived from his property except with the authority of law. So the right to property in that sense is still a constitutional right, but not a fundamental right. If there is a fair procedure, there is authority of law, and just compensation is paid to a landowner whose land or structure or trees or fruits are acquired, then in that case, that land acquisition proceeding is as per constitution, and no claim can be made for revertment of that particular land. So in constitution, you guys will find only these two provisions, one repealed and one existing. Now coming to the particular provisions of Land Acquisition Act 1894. In this act, if you guys must have went through this act, it provides for section 4, which state that the government must first of all show his intention to acquire the land. Now, it is also important to see the exact wording of that particular law in order to understand it in more particular, more proper way. The section 4 of the Land Acquisition Act 1894 provides for publication of preliminary notification and power of officer thereupon. This notification is published in the Gazette of the particular government or the appropriate government, that is either the state government or the central government, which is carrying out that particular acquisition proceeding. Now, for example, the government has decided to create a new rail line between two particular cities. So in order to construct that particular rail line, government will be requiring a particular land in that particular area. So the surveys are conducted, and after conducting that survey, this section 4 notification is issued in the government of India Gazette, because this railway is the central government ministry, and acquisition therefore for any land that is required for railway is carried out by central government. In this notification, a brief description of land is mentioned. The district in which land is situated, the name of that particular district is mentioned. Taluka, name of taluka is mentioned. Name of village, name of number of that particular land. In Rajasthan, we call it khasra numbers. That khasra number is mentioned, and the measurement of land that is required from that particular khasra number, it is mentioned. So in this brief description of land is mentioned in this section 4 notifications, and objections are called from all the interested persons. Now, it is important, therefore, for us to look into the definition of interested person under the Land Acquisition Act 1894. Before proceeding, I must also pause here for a moment and must apprise you guys that currently in India we have 2013 Act, which the complete name of this act is the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. This act was made applicable in our country from 1st of January 2014, except for the acts which are provided in Schedule 3 of that particular act. Therefore, currently we have different law, but that does not mean that the Land Acquisition Act 1894 has lost its relevance. That is because all the proceedings which were carried out under the old act, that is Land Acquisition Act 1894, and any dispute which is currently in any court, then the law which will be governing that dispute is that Land Acquisition Act, that old Land Acquisition Act. Therefore, we must know a brief description, brief procedure which is provided under the Land Acquisition Act 1894. And once we complete this, we will go in detail and read out current Land Acquisition Act, that is 2013. Coming back to our Land Acquisition Act 1894, we have Section 4, as I already told you guys, that it is the preliminary notification calling for objection from all the interested persons. Now, interested person, definitely the owner of the land is interested person. Apart from that, the person holding easementary rights are also interested persons. Suppose someone is staying on rent in particular premises, and that premises has been proposed to be acquired. The tenant is also considered as interested person. Therefore, objections are called. Those objections are submitted before the competent authority land acquisition or the land acquisition officer, who is appointed also by the central government. In Rajasthan, generally you will see the subdivisional magistrate of that particular division is the competent authority. Apart from few exceptions like in Jaipur, Tonk, the concerning additional district magistrate has been entrusted with the powers and functions of LAO, that is Land Acquisition Officer. Those objections which are submitted by interested persons are heard and decided by that particular LAO having jurisdiction over that particular land. Once those objections are decided, then the LAO sends a report regarding decision of those objections to the central government, and central government finally issues section 6 notification, or in other words we can say central government used to issue notification under section 6. That notification is the final notification, and any land which has been mentioned in that particular notification is acquired by the government and vested with the particular government, appropriate government, free from all encumbrances. The term free from all encumbrances is very much important because there can be mortgage on particular land, there can be a tenant, there can be any other loan. So all these things are kept aside and the land vests in central government, thereby meaning thereby that land is now can be used by central government for that particular purpose. Thereafter, again objections are called not with respect to acquisition of land, but with respect to and determination of compensation. As we have seen in the starting, the landowners whose land is being acquired by the government have right of fair compensation. Now, the term fair compensation, as small is as complicated, because a fair compensation to me for a particular land cannot be a fair compensation to you guys. For example, suppose I'm owning a land in Jaipur and the central government has declared that land to be acquired for particular purpose, let's say for construction of national highway. Now the LAO, who is the land acquisition officer, will determine the compensation. There is provision under the act, that is section 23, which provide how the market value of the land has to be determined, what are the other factors which has to be considered by LAO, how the interest has to be calculated. And under the Land Acquisition Act, there is one word, solatium. The word solatium means an amount given in return because of the compulsory nature of acquisition. Since all the land acquisition by the appropriate government is a compulsory acquisition, meaning thereby that landowners cannot deny or cannot say that we are not going to give our land. This being the compulsory nature of acquisition, a particular amount as a solatium is being given. Under the Land Acquisition Act 1894, it was earlier 15% of the market value of land. Subsequently, it was amended and increased to 30%. Under our new law, as we will be studying, it is 100% of the market value of the land. Therefore, this is one of the reasons that the new Land Acquisition Act is considered a little landowners friendly as compared to its earlier law. So that fair compensation is being determined by the LAO, and I, being the landowner, will never be satisfied from that particular amount which has been given by LAO. Suppose the LAO has decided compensation of 1 lakh rupees for my land which is being acquired. I will go to court and challenge it and will ask the court to give me 10 lakh rupees or 20 lakh rupees as the fair market value of that particular land. So this is the one point where the dispute arises with respect to determination of compensation. In this, in these type of cases, one part is that particular landowner whose land has been acquired. Another party is the department of that government which has acquired the land. In case of railway, the railway department. In case of highways, national highway. In other case, like if the land is acquired for state highway or by PWD, in that case PWD will be the concerned government department, and they will contest the case, and the particular authority under the Land Acquisition Act reference is made to civil court. Under the Railways Act or the National Highways Act, a provision is provided with respect to arbitration of that particular dispute. Arbitrator is appointed by central government. In Rajasthan, we guys see that district collector of concerning district is generally appointed as arbitrator to look into the dispute with respect to determination of compensation. In Himachal Pradesh, the central government has appointed divisional commissioners as arbitrators. So it cannot be any authority, but that authority must be authorized by the central government to act as an arbitrator. The main task assigned to arbitrator under the law is to hear both the parties, take documents regarding the fair market value of the land, and after hearing all the parties, decide that what is the fair market value of the land which has been acquired, and what amount of compensation a particular person, like if my land is acquired, then I will be entitled to. So this is one type of dispute which we generally see in the land acquisition law. Second type of dispute is with respect to entitlement. This means that a person A and person B are both claiming right in a particular land which has been acquired by the central government. In that case, the concerning LAO first of all look into the dispute, and if after considering the documents submitted by both A, B, if they think that A is entitled, then he can make an award in favor of A. But the dispute is of such complicated nature which cannot be decided by the LAO. In that case, under the Land Acquisition Act, the LAO refers that matter particularly to the civil court, and the amount that particular for that particular land, the compensation amount is deposited with that particular court. So this is the second type of dispute. Third and important, which was not existent in the earlier law but it is now there, is rehabilitation and resettlement. We generally see that the state government and central government acquires land. From their perspective, they are simply acquiring a land for public purpose, because construction of highways, railway, uh, industries, new industries, RECO acquire land for certain purpose. In Rajasthan, the land was acquired for refinery. These all acts are of public purpose. Therefore, from the government perspective, they acquire land for public purpose. But when we think from the perspective of a landowner, who suppose in major case is an agriculturist, now from his angle, his only livelihood is going. Therefore, the under new law, government thought it appropriate to insert the provision relating to rehabilitation and resettlement. So apart from compensation, there is rehabilitation and resettlement, and whether the fair rehabilitation and resettlement has taken place in that particular case is also one type of dispute which generally comes. So under the Land Acquisition Act, These all disputes, I would not say are short dispute or decided within a year or two. There are many cases which are going on for years and years, and still they are before either High Court or Supreme Court fighting for their rights. So this was the basic background of our Land Acquisition Act 1894. Now we will see certain provisions which are different from our old law under the new act, and how this new act is termed to be landowners friendly. There is always a debate for the new act that one side of persons say that this act is more landowners friendly, thereby making it difficult for particular appropriate government to acquire land under this act. Why they say so? Because first of all, there is section 4 in this 2013 act. The section 4 provides for social impact assessment. Now, what is social impact assessment? The government says that whenever the government intend to acquire a land, they must not sit in particular four-wall room and decide that they are going to acquire land. They must approach concerning persons who are affected by those land acquisition, take their consent, tell them about the acquisition, and see what are the environmental consequences of that particular acquisition, how many persons are going to be displaced, how many agriculturists are going to lose their livelihood because of that particular acquisition. Therefore, a committee is constituted to carry out this detailed social impact assessment with the help of the persons whose lands are going to be acquired. This committee then submits its report to the government, and government, on the basis of that report, decides whether they require that particular land or not. Once they decide that they require that particular land, again the same process follows. The Section 4 notification on earlier act is now substituted by Section 11 notification, which is the preliminary notification, whereby the government shows its intention to acquire the land. Objections are called, objections are heard, and in most of the cases, these objections are dismissed. Anyhow, the LAO competent authority again sends its report to the central government, and another declaration notification is issued. The important provision under the new act is section 24, which talk about the lapse of acquisition proceeding. Section interpretation of section 24 was made by the constitutional bench of our Supreme Court in the case of Indore Development Authority. And the issue regarding the lapse of particular acquisition proceedings, if possession has not been taken and compensation has not been made, has been decided. Those of you who are interested in this particular land acquisition law must go through this Indore Development Authority judgment, which is really a Bible and will give you more knowledge on this land acquisition. So this section 24 interpretation was made, and apart from this, there is section 26, which talk about determination of compensation. In every land acquisition proceeding, as I earlier told you, determination of compensation is the main thing. The interpretation of these provisions is on which the advocates play. Because as a general landowner who is an agriculturist, he cannot be expected to know the law for determination of compensation. The persons, if you will go and talk to such persons whose land has been acquired, you will see that they are generally of the mindset that once the land has been acquired by a particular government, they have no other option but to take that compensation whichever is offered by the LAO and sit quietly at their house. But this is not the case. All of you, if are aware of any land acquisition in your area, you guys must go visit them, and tell them at least about their right to challenge the determination of compensation. Because in Rajasthan, we generally see that the LAO determine the compensation by taking the DLC rate, district level committee rates, as market value of that particular land. But we all are aware that DLC rates, which are fixed for the purpose of deposition of stamp duty when a particular land is sale, cannot be considered to be the real market value of a land. Why? Because when we conduct a registry of particular land, owner of a land is selling and one another person is buying that land, we try to save the amount of stamp duty and therefore we register that particular sale deed on base value and carry out rest of the transaction in cash or in any other mode. Therefore, the DLC rates which are made applicable by the land acquisition officers are not the correct market value of the land. But the persons who challenge this determination can only get relief. The persons who are mum sitting at their home after taking compensation will not get the benefit of the real market value of land. And it has been seen that the real market value of land is around 4 to 5 times of the DLC rate. Meaning thereby, if a person has been awarded compensation at, let's suppose, 10 lakh rupees, if he contests that particular case, submits documents with regarding the fair market value of land, can get 5 times, that is 50 lakh rupees as compensation. Although this fight is long fight, because the authorities generally do not go against the government, but if we have documents which show the real market value of land, in that case there are certain persons whose compensation has been enhanced by the concerning department, authority, or in that case arbitrator. We will go through section 26. I have not read any other section, but section 26 is very much important. Therefore, we will go through this particular provision and we'll try to understand as to how the compensation is being determined by the LAO and what are the factors currently which are being considered by LAO for the purpose of determination of compensation. Section 26 starts with determination of market value of land by the collector. So under the Land Acquisition Act, collector is concerned, is entrusted with the powers of LAO. Under the NH Act, the subdivisional officer or the ADM, additional district magistrate, is entrusted with the power of LAO, and the collector under the National Highways Act acts as an arbitrator and not as an LAO. So this is the important point which you all guys must note down: the difference between the LAO and the arbitrator, and how the term collector in that part used in section 26. If we will made reference to NH Act, then this term will be substituted by subdivisional magistrate or the additional district magistrate. Now section 26(1), the collector shall adopt the following criteria in assessing and determining the market value of the land. Section 26(1) provide for 3 criteria which are required to be considered by the collector. And these 3 criteria, it is not an option with the collector that he can take any one of them and leave 2 of them, or take 2 of them, leave third of them. Why? Because at the end of this provision, it is written that the rates whichever are higher must be made applicable. So there are 3 ways in which collector will first try to determine the market value of the land. And after determining market value of that particular land which is acquired, the highest determined market value will be taken for consideration for determination of compensation. What is the first way in which the collector is required under law to see the market value of land? The first is the market value, if any, specified in the Indian Stamp Act, or if there is state government, then the act which is of state government, for registration of sale deed or agreement to sale, as the case may be, in the area where the land is situated. Now, suppose my land situated in Sikar or in Jodhpur is acquired. Now, the collector under law is duty bound to consider the relevant sale deeds or the rates which are fixed for registration of those sale deeds. This is the first task of the collector, to see the rates that are fixed for registration of sale deeds or agreement to sale. In general sense, DLC rates are those rates which are fixed. Therefore, the collector, after considering this A, 26 bracket 1 bracket A, fixed the DLC rate. But they forgot to take into consideration 26 bracket 1 bracket B. What is 26 bracket 1 bracket B? The average sale price for similar type of land situated in the nearest village or nearest vicinity area. Meaning thereby, if my land is situated in Sikar, Jodhpur, the collector is also required to take into consideration the rates which are outside that particular village, particular district. These rates are difficult to find because there are 4 to 5 districts which are situated near a district, 4 to 5 villages which are bounded by one village. Now, collector, rather than going to all those villages and trying to find out what is the real market value, he escapes this particular provision. So this becomes a major bound for litigation in land acquisition. Now coming to say 26 bracket 1 bracket C. It says consented amount of compensation as agreed upon under subsection 2 of section 2 in case of acquisition of land for private companies or for public private partnership projects. There are certain type of acquisitions where a land is required for, let's say, installation of a cement factory. In those cases, the cement factory requires minimum of 100 biga, 200 bigas of land for installation. Then the particular company, let's say Ultratech Cement or any other company, will go to government, will propose to them that we are intending to install this particular industry infrastructure for our factory, and ask the government to acquire the land and give it to particular company. And in these cases, compensation is generally determined by way of consent between the landowners and the company. So the collector under 26 bracket 1 bracket C is also required to consider those rates which were consented by the landowners and the company if any acquisition of that type has taken place. And after considering all these rates, it says whichever is higher. The rate whichever is higher after considering A, B, and C has to be taken into consideration by the collector for the purpose of determination of market value of land. Now there is proviso to this particular section, which is provided that the date for determination shall be the date on which the preliminary notification under section 11 is issued. You guys must be remembering that we spoke about section 4 under the old act and section 11 notification under the new act. The date on which that notification is published in the gazette, the rates of or the market value of the land has to be considered of the said date. For example, the notification was, let's say, issued on 1st of January 2024, and the award, which is passed by LAO, that is Land Acquisition Officer, is in the month of July 2025. Now, the LAO will not consider the market value of that particular land in July 2025. Rather, under law, he is required to consider the market value of that particular land on 1st of January 2024 when the first preliminary notification by issued by the government. Although LAO under section 30 will give interest from that preliminary notification to award date at the rate of 12%, but the market value has to be considered from the date on which were existing on the preliminary notification. There are certain explanation to this section 21, 26 bracket 1, and thereafter there is section 27, which provides for determination of compensation. There is section 28, which provides for parameter to be considered by collector in determination of award. 29 talks about determination of value of things attached to land or building. This provision is important because in some cases there are house constructed on land. There are irrigation activities which are going on a particular land which is being acquired. Or there can be garden, plantation, tube wells. So when a land is acquired, compensation with respect to those structure, house, industry, fruit trees, non-fruit trees, garden, all those amounts have to be calculated and has to be paid to that particular person whose land has been acquired or whose house has been acquired. That determination is done by the collector or that matter LAO under section 29. Under section 30, the LAO give solatium at the rate 100%. I spoke a little bit moments ago that now under new law, 100% solatium is given to the landowner, and that 100% solatium is of the market value which has been determined under section 26 in case of land and in case of structure in section 29. So suppose if the market value determined by the collector of a particular land is 1 lakh rupees, he is going to get another 1 lakh rupees as solatium, and in total he will get 2 lakh rupees of that particular land. Same with the case of structure and compensation of structure and compensation of trees also. Apart from that, section 30 also provide for interest, as I spoke. So in total, this award is prepared by collector. This award, if I am, let me check if I am able to share my screen. I will show you the award. What is the format of award and how it is passed, so that it can be clear in your mind. Just a moment. Anyone please confirm that you guys are able to see my screen. Please confirm.
Yes, sir.
Thanks. So this is an award passed by Additional District Collector First Halwar. You guys can see at the beginning he have written about the act under which the acquisition proceeding was carried out. This acquisition proceeding was carried out under National Highways Act 1956, Section 3G, and the compensation was determined under the new Act of 2013. Now there is this interesting combination of these two laws, and the main purpose of our today's class was to discuss this interesting combination, but I think it will not be possible today. We will keep it for next class. But it is interesting from the aspect that earlier the land was acquired under, if the land was acquired under the National Highways Act 1956 before 1/1/2015, meaning thereby till December 2014, if any land was acquired by the central government under the National Highways Act 1956, the compensation was also determined under the provisions of National Highways Act 1956. But after 1st of January 2015, if any land is being acquired under National Highways Act 1956, The compensation is determined as per Schedule 1, 2, 3, 4 or Section 26 to 30 of the Land Acquisition Act. Now, how this is happening, why this is happening, what are the reasons that the determination of compensation has been taken from this new act and the acquisition proceedings are being carried out under the old act. These are few important points that we have to discuss, and you guys will find this very much interesting, that how two laws relating to determination of compensation of one particular land is currently in existence. So we will discuss it in next class, because I think today we have already out of time. But still, this is the award. You guys can see Adhinirnay Adesh. This is award. This is award of village Dorala, Tehsil Reni, district Alwar. And at the beginning, he start writing about the particular notification or letter by which he has been authorized to act as an LAO, that is Land Acquisition Officer. Those theory he writes. Thereafter, he write about the notification. Since this is an award under National Highways Act, the notification, that preliminary notification, as we discussed earlier under Section 4, under New Law Section 11, under National Highways Act, it is issued under Section 3. This notification is issued. He write about that notification. This notification is also published in newspaper, two newspapers, details of which is also written. Thereafter, there is the Section 3D notification. The notification whereby the land mentioned in this notification vest in that appropriate government, free from all encumbrances. He write about that particular notification also. After that, in this award, he writes about the land which is acquired, land situated in Tehsil Ye, village Ye, Khasra number, as I told you. Type of land, Niji, private land. Sometimes the government also require the land which is already owned by state government. In that case, you will find Sarkari or government land mentioned here. Nature of land. Nature of land plays a key role in determination of compensation, because the DLC rates at which the LAO fixed the market value of land is dependent upon the nature of land. DLC rate of agricultural land is different. DLC rate of commercial or industrial land is different. Even the DLC rates of agriculture, which is Sanchit, Asinchit, Barani, Doyam, Barani 2, Barani 3, is also different. Therefore, this plays a key role in determination of compensation. And finally, he writes about the area which is being acquired. Subsequently, Bhumika Bajar Mulya, this is the theory about how he has determined the compensation. You guys will find he have reproduced section 25 to section 26 in his award. This is section 26 in Hindi. The 3 points which I earlier told you, the proviso and these explanations. Then this is Gunank factor, multiplication factor, which is also a new concept under the new law. He mentioned that how he has made this multiplication factor applicable in this particular acquisition award. Thereafter, he mentioned about the 100% solatium, the interest we have already discussed. And finally, he mentioned about the disbursement of compensation to the person interested. In this, he have written the amount. And there are also these type of sheets. I think these are not in this award. There is also sheet attached to this particular award, in which the determination is made Khasra. So this is an award, a performer, or we can say real award, which is passed by LAO. Formats may differ from case to case. Like in railways, there may be some differences. There will be difference of provision, because in those railway case, the acquisition is made under Railways Act, not under National Highways Act. The provisions will be different, but the procedure in both these acts is almost same. The same determination, same arbitration, then provisions of Arbitration and Conciliation Act 1996 are applicable. Therefore, any objection from the award passed by arbitrator goes under section 34 of the Arbitration and Conciliation Act. Against that order, the appeal goes under section 37. So the provisions of Arbitration and Conciliation Act are also applicable, and therefore we will go through them very briefly, not in detail. So in today's class, I was hoping that we will be able to reach that differentiation part. But anyhow, I suppose that you guys have find this information useful. But at the cost of repetition, I will only say one thing again. If you guys are interested in this particular law, there is ample scope in litigation, considering the high amount of acquisition made by government and low amount of knowledge, not only to landowners but also to the advocates who are practicing in the land acquisition side, because the law have developed less from the provisions but more from the judgments of high courts and Supreme Court, and those judgments are not regularly studied by the advocates and never studied by the landowners. Therefore, I think that you guys must start practicing, think at least think about practicing in this direction, and find a beautiful and big career in this particular field. Now, since the time is over, still, if anyone have any question or any suggestions regarding our next class, which will be on the interconnection between National Highway Act and 2013 Land Acquisition Act, can turn on their mic and start. Anyone? Anything? Anything beyond this topic? Thank you, Ganika. Fine. In that case, I presume that you all have understand what we have discussed today. And in next class, we will take brief recap and we will go into this interesting interconnection between these particular laws. Thank you. Thank you so much.